The topical area is the election date. Please describe the standard to be applied for scheduling an election. The proposed rule stated that the regional director should select an election date which is as soon as practicable. If you disagree with the standard, please describe the standard you would apply. Specify whether you think the rule should include a minimum or maximum time between the filing of the petition and the election. And if so, how long this time should be. Also address whether the proposed rules adequately protect free speech interests. If you believe they do not, please so state, and state specifically how the proposal can be adapted to adequately address the matter. The first seating we have Joseph Torres, Brian Petruska, Elizabeth Melito, Edgardo Villanueva, and Glenn Rothner. Mr. Villanueva.
Thank you. Good morning, Mr. Chairman and distinguished members of the board. I'm Edgardo Villanueva, president of EMSI Consulting, a management consulting labor relations firm based in Chicago. In your terminology, I am a persuader. Of course, unions have come up with other more creative names for my profession. Given the limited time I have, let me establish up front that I feel that reducing the time frame from the filing of a petition to election day is simply unfair to the employees, the voters, who are faced with making a very important decision of significant long-term impact to their working lives and pocketbooks. I'm sure you've heard that in the circles that I represent, that is management, this potential change is referred to as ambush elections. Based on my 32 years of hands-on, face-to-face contact with thousands of eventual voters in NLRB elections, I feel that the term ambush would apply to the voters more so than to the employers. Of particular concern to me, and the focus of my presentation here before you, is the multitude of situations I have faced where the employees in the voting group are predominantly Spanish-speaking immigrants from various countries in Latin America who have never had exposure to the nuances of the National Labor Relations Act that you oversee, and whose only point of reference about unionization are the labor laws of their own country or the appealing promises of a trained union organizer whose job it is, ironically, to persuade them to vote for the union, and who may either be guilty of a sin of commission by not stating the truth, or even worse, a sin of omission by failing to inform the workers of the whole story. Mr. Chairman, after meeting with countless employee groups in many diverse industries across the country, and even in Puerto Rico where the Act applies, I have personally experienced and seen the total lack of understanding or a profound misunderstanding about the National Labor Relations Act that these employees have as they prepare to go to the voting booth in an election conducted by your agency. I could relay many anecdotal situations of employees reciting totally inaccurate understanding about the collective bargaining process in this country, or about the devastating potential of permanent replacement in economic strikes, or even having a knowledge of what a union security clause is, et cetera, et cetera. Given this reality, Mr. Chairman and members of the board, I urge you to not take away the right of these workers to have ample time to get the facts and hear both sides of the issue, just as you are doing here today in this hearing, and simply be fair to them, the voters, by allowing them enough time to become informed on all aspects of their decision in the relatively short time frame they have while juggling work and family obligations. I'm not asking for more, but simply asking you to let them keep the standard plus or minus 42 days that the NLRB has historically established as a workable and fair time frame for these employee voters to become educated on what is a complex and important law. Taking away this educational period would not be favoring unions nor giving management a disadvantage or the other way around, but it simply would be unfair to take away the rights of employee voters to make a truly informed choice. You've heard eloquent legal arguments from what was referred to yesterday as the creme de la creme of legal minds for and against streamlining the election process. And in some ways, I think there is a need for some of that. You've heard from union organizers and now a management consultant. However, not from a single worker, the average voter, who is no expert in U.S. labor law, especially those that immigrated to this country. I wish you had. Therefore, on this one key factor, that is, the time frame employees need to educate themselves, I strongly suggest that you be fair with them and give them the realistic time they need to understand a very complex subject. Mr. Chairman and members of the board, I sincerely thank you for the opportunity to speak before you today, and I hope that you will take my observations into account as you make your eventual decisions. Thank you.
Thank you.
I think we did hear from some workers yesterday.
I'm sorry?
I think we did hear from some workers yesterday.
Oh, okay. I apologize.
You may not have been here.
I may not have.
Right.
Yeah.
I apologize, but
Let me just
Go
go
ahead.
more directly to your point. It sounds like your point is that employees don't have enough information about the law. Am I correct?
yes, but specifically, so my experience, again, as I mentioned in my presentation, is that employees who have immigrated to this country, their understanding about the law is mainly, if any, based on what they know of, let's say, labor laws in Mexico or Guatemala.
Right. So let's assume that we improve our bilingual outreach efforts. Let's assume we have better notices. Let's assume that we can do something internally to help educate people more quickly. Does that take away your concern and then allow us to have an election timetable that doesn't rely on that as a source of delay?
Well, the board, of course, already provides much of its material in multi-languages. And in fact, in the course of the meetings, captive audience meetings, as we referred to earlier, we present that, the National Labor Relations Act in Spanish, based on the literature the board provides. So I think the board, gives enough information. My point is that it just takes that much time. So as I said, I think that the standard that is currently in place is enough, frankly. I'm not saying that we need, 10 weeks or 6 or whatever, but 4 to 5 weeks or thereabout. And as was mentioned also by Mr. Petruska, a lot of times these elections are going to be scheduled on a particular payday so that we encourage, participation. And so it's a question of giving enough time. Also remember, Chairman, Mr. Johnson, is that these businesses, and also Ms. Melito made the point, they're busy, they're working. So we don't meet with them, like in a span of 10 days, we wouldn't meet with them 10 days. We might meet with the employees once a week, let's say. So 3 or 4 sessions with them to explain what is a complex law, I think would be fair, is fair to them. So I'm simply asking, don't change it or reduce it, if I answered your question.
You mentioned that you used the term persuader, and actually that's not a National Labor Relations Act term, but when you called yourself a persuader, as I understand it, I'm not sure it was entirely clear, you work for companies?
I do, yes.
So you're persuading on behalf of the company?
That's right.
Okay.
Yes.
And to follow up on what Member Johnson asked, in the proposal, a notice to employees that normally now goes out when a petition is filed would be required to be posted in the workplace. And in your experience, do employers now post that notice?
Many do, although if I recall, and I don't have it in front of me, the indication and typically is that the notice, are you referring to the notice of election that it should be posted 72 hours before the election?
No, the notice to employees that goes out when the petition is filed.
Some do, some don't, because it's my
some
understanding.
do, some don't. And don't you think it would be useful to employees to have that information as soon as the petition is filed, and that would help with some of the concerns that you have outlined?
That would be fine, but the board, but the notice that you're referring to that comes with the initial package, if you will, including the petition and so forth, it outlines the law or some aspects of it. But the further explanation of what that means and the implications to them should they decide to unionize, et cetera, is what we try to educate people about during the course of these meetings. And so because businesses have to run their business, we typically, as I said, have an opportunity to meet with employees perhaps once a week for 45 minutes to an hour. And so 3 or 4 of those 45-minute sessions is just barely enough to be able to actually educate them on, let's say, the collective bargaining process or, other aspects of what unionization entails for them.
Well, you're a contractor for the employer, aren't you? When
Yes.
you come in?
Yes, sir.
So the employer can kind of dictate how much time you have with the employees. And you certainly are able to go right into the workplace and speak directly with the employees.
Yes, sir.
Right? During work time.
Yes, sir.
Right? During those, what has
Yes.
been referred to as captive audience meetings.
That's common terminology.
Right.
Yes.
And some of these employers, I understand, might have an intranet where they communicate electronically with the employees.
Well, certainly it's becoming more and more popular.
Right.
Yes.
And they can deliver messages on that intranet as well.
Mr. Chairman, they certainly can. It's not my general experience from, again, being on the ground, that is the favorable way of communicating with them, face-to-face, talking, answering their questions, yes. And that's what I am asked to do on behalf of the employer.
Right.
Also, Mr. Chairman, although the internet and computers and social media is becoming more and more popular, I meet with a lot of people who, don't have computer skills
Of
or
course,
may not have a
yeah,
computer at
sure.
home. So it's not the standard way of communicating through the internet. It's not the standard way of communicating.
But the point that I'm
Face-to-face
making
conversation.
is that face-to-face is an option that you have, and you have as much of an opportunity to communicate with the employees as the employer will permit. Wouldn't you say that?
Right, the employer, but when you say the employer, of course, Chairman, just to clarify, as their business will permit. They have a business to run, whether it's, whatever type of business it is. So, yeah, as I said, standard, a situation is that we get a chance to meet with employees in, small group settings or whatever, present information, give them, and answer their questions. Probably, as I said, 45 minutes to an hour per week, if you will. So if we have a 3-week or 4-week period before the election,
Right.
you might have 4 opportunities to educate them about a complex issue.
But that time period is dictated by the employer determination as to how much time
Of course,
it
schedule.
wants to give you.
The answer is yes. Of course, the employer, determines when it is convenient or possible to keep the business running, and while allowing these individuals to get the information that we want to make sure that they understand.
Okay?
Yes.
Thank you.